Dear students, viewers and the subscribers, welcome to the IAS Mentor. You are watching episode number 9 in the series Indian Polity Current Affairs for Prelims 2025. Now, the objective of this particular series is to cover the 50 most important topics which may be relevant for the Prelims examination 2025. As I promised in the beginning, so today I will be taking up the miscellaneous topics, and today in this particular episode I will be covering around 10 topics. Including these 10 topics, if you go back to my previous episodes, I have covered 50 topics. So these are the 50 very relevant based on previous year UPSC questions. These topics has been chosen from the last 1 year. So I have gone back from May 2024 till April 2025. So all these things been covered in this particular series. Now I also promised to the students that I'll do a questions on these particular topics, because if you look into the topics in the various episodes, I have just only done what is called as the discussion of the topics. So coming Sunday, that is on 18th May 2025, I'll do a live session where I'll cover 50 questions from these 50 topics. In a way, it will be revision of all the 50 topics as well, and also in a way that you will also solve the questions. I know that the time is very important for the students, so I'm not going to take much time for this particular question answer discussion from the current affairs in the live session. It will be a 90-minute session, maybe a little more than that. So I'll make it very crisp, and in the same time I'll try to solve the questions. So therefore it will be a one-stop revision probably for the student just before going to the prelims examination. So if you watch this particular video, please see the question answer discussion on the live session on 18th of May 2025 at 2 p.m. in the IAS Mentor channel. Alright, so with that I'll just go to the topics that you have to discuss today in this particular lecture. So the first thing is, one of the topic that I wanted to discuss is the privilege motion on Mr. Amit Shah. Although I am putting it under miscellaneous topic because I missed out when I was taking the legislature part. Now what was the relevance of this particular news? Because many parties, including the Congress party, they tried to introduce a breach of privilege motion against Mr. Amit Shah. In fact, Mr. Jairam Ramesh from the Congress party, he wanted to introduce a privilege motion against Mr. Amit Shah on the grounds that Mr. Amit Shah has misled the other members of parliament on the Wayanad natural disaster. We know that some time back there was a landslide flood that has happened in Wayanad, and during the discussion in the parliament, Mr. Amit Shah has said that the Kerala government has been issued warning by the central authority, and in fact a red alert has been given before the natural disaster has struck Wayanad. So when this was a statement which was made by Mr. Amit Shah, there was an allegation from the opposition party that this is a misleading statement. There is no fact behind this particular statement. Anyways, I am not getting into the discussion of whether there is a fact or not. But as per the parliamentary conventions, we know that that what has been followed in our country is when any member of parliament misleads other members of parliament. It could be a minister or a member of parliament. Anyone who misleads other members of parliament, that can be seen as a breach of the parliamentary privilege. And for the breach of the parliamentary privilege, the parliament can take action against a member who has breached the parliamentary privilege. And for that, there is a procedure that is to be followed. And whenever that motion is admitted, because that motion has to be first admitted by the concerned presiding officer. If it is admitted, then there are certain things that may happen. So the questions are likely to come from any of these areas. So basically, what is a privilege motion? A privilege motion is introduced to see whether a particular member has misled the other members of the parliament, or whether a minister who has misled the other members of the parliament, thereby breaching their privilege. Alright, so further, in addition to that, what are the grounds on which moving a privilege motion? What are the grounds on which it can be done? Although these things are not directly mentioned in the constitution, apart from the privileges being given to the members of the parliament, but nothing is dealt about the privilege motion. What are the grounds on which it can be done? If a member of parliament misleads the other members of parliament, so misleading statements, misleading information, publishing false report about the house proceedings. That is also a ground. Obstructing an MP from performing their duties. Anyway, if they obstruct the other members from performing their duties, disrespecting the parliamentary process, breach of confidentiality of parliamentary committee. As someone being a member of parliamentary committee, they should maintain certain confidentiality. When they breach the confidentiality clause, these are all the grounds on which the privilege motion against a member who has done all these things can be introduced. Now, very quickly, what is the procedure as to how the privilege motion can be introduced either in the Lok Sabha or Rajya Sabha? So, first of all, a written notice has to be given to the presiding officer as to the intention of a member to introduce what is called as a privilege motion against an MP or a minister who has breached a privilege. The speaker or the chairman has the discretionary authority about the admissibility of such motions. It is not necessary in all the cases it will be admitted. Say, for example, the privilege motion that was to be introduced by MP Jairam Ramesh against Home Minister Amit Shah was not accepted, was not allowed by the chairman Rajya Sabha. So, therefore, the admissibility is upon the discretionary power of the presiding officer. If admitted, the matter may be referred to a committee on privileges. In fact, there is also something which is called as committee on privileges. If the motion is admitted in the Lok Sabha, it will be referred to the committee on privileges in the Lok Sabha. If the matter is admitted by the Rajya Sabha, it will be referred to the committee on privileges to the Rajya Sabha. Once a matter is admitted, then what will happen is then they will have a discussion and they may give the report back to the House as to what kind of actions may be taken upon. If you see the privilege committee, normally there are 15 members in the Lok Sabha, 10 members in the Rajya Sabha in this privilege committee. All the members are nominated by the respective presiding officers. If it is sent to the committee may examine and give the report back to the House, and further the House may debate on this particular matter. Finally, they may put to vote and take appropriate action against a particular member. So, what could be the consequence against a particular member? They may ask the member to send give a formal apology, or they may censure a particular member for doing this. In serious cases, there may also be a possibility of what is called as imprisonment of that particular member. Although that's a very rare case. So, these are all the possible consequences that may likely to happen if action is taken by the House on a person who has breached the parliamentary privilege. All right. The second topic that I wanted to discuss you today is as to how the PESA has boosted the forest conservation in our country. Now, we know that there was a report that is published in various newspapers as to how PESA, that is the Panchayat Extension to Scheduled Areas Act. This PESA Act was passed in 1996. This PESA Act, the very objective of this was as to how the PESA, the very objective of this PESA Act is to bring in a system of Panchayat Raj system in the Schedule 5 areas. That is what is the objective of the PESA Act. But how PESA Act has boosted what is called as forest conservation in our country. That is a current context, but I am sure that the questions are likely to again come from what is called as PESA Act. Not only from PESA Act, but also from what is called as a Forest Right Act. These are two important pieces of legislations that has a lot of impact upon the tribal people in our country. So, therefore, as a part of this current affairs, I will also touch upon these two important legislations. One is the PESA Act, the Panchayat Extension to Scheduled Areas Act. Another is also the Traditional Forest Dwellers Act, which is also called as a Forest Right Act. So, I will just quickly discuss, and in the process, you will also understand as to what is the difference between these two acts. If you look into the PESA Act, which was enacted in 1996, and the major objective is to empower or to bring in a system of what is called as Panchayat Raj institutions in the scheduled areas, which is covered in the Schedule 5 of the Constitution. Therefore, it should be very clear in your mind where the PESA Act applies. The PESA Act applies only in case of the Scheduled 5 areas. But you can ask me, sir, we do have the 73rd Constitutional Amendment Act, which provides for a Panchayat Raj system. The Panchayat Raj system does not apply to the Schedule 5 areas. Neither it applies to the Schedule 5 areas nor to the Schedule 6 areas. So, it only applies to the other parts of the country. But when it comes to the scheduled areas, which is covered under Schedule 5 of the Constitution, the scheduled areas are today there in 10 states in our country. It may be extended to other areas also. Under the Schedule 5 of the Constitution, it is a president who will determine as to which areas can be brought under what is called as scheduled areas. Predominantly, the scheduled areas are those areas where there is a predominant tribal population. So, in all the states in India, the president can declare certain area to be a scheduled area, provided if there are a significant tribal population in that particular area, except in states of Assam, Meghalaya, Tripura and Mizoram. In case of Assam, Meghalaya, Tripura and Mizoram, in those areas, the Schedule 5 does not apply, the Schedule 6 applies. So, wherever the Schedule 6 apply, there is no PESA Act. Wherever the Schedule 5 areas are there, declared by the President, there the PESA Act will be there. So, what is the objective of the PESA Act is to bring in a system of local governance in those Schedule 5 areas, and thereby also to empower what is called as Grama Sabha under this particular act to decide a number of things. So, therefore, what is a major objective is to ensure that to bring in a system of local governance and to empower the people through the system of local governance is basically the major objective of PESA Act. So, what are the major provisions of this PESA Act? It ensures that there is self-governance in the Schedule 5 areas. It ensures that the customary laws are being recognized by the local governance in that particular area. It also ensures that an element of land rights are given, so that the outsiders cannot come and take the land, and to that extent the Grama Sabha is given such a power. It empowers them to take care of their forest and water resources, mining and developmental activities. So, all these powers are conferred upon the Grama Sabha by the PESA Act. It also empowers the local community to have control over certain institutions through their Gram Sabha, and then they also have what is called as dispute resolution mechanisms, which empowers the Gram Sabha to resolve disputes through their customary methods. So, this is basically the various provisions of the PESA Act. Try to have a larger objective, that is more than sufficient to answer the question. And then students do get confused with what is called as a Forest Right Act. So, what is this Forest Right Act? Now, try to understand, while the PESA Act is applicable only in the Schedule 5 areas, not in the other areas. But whereas what is a Forest Right Act? The Forest Right is applicable throughout the territory of India, wherever there is a tribal population. That is basically what is called as the Forest Right Act. Also called as the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Right Act 2006. Commonly called as a Forest Right Act. The major objective of this particular act is to recognize the traditional rights of the forest dwellers, the land rights and the rights over the forest of the forest dwellers. They need not be a scheduled caste, but if they are a traditional forest dweller, then also they may exercise these rights under the Forest Right Act. But predominantly who is dwelling in the forest is the scheduled tribe. So, whoever is in the forest area, they are all entitled for certain rights under the Forest Right Act. So, here the Forest Right Act is not trying to provide a system of governance as in case of PESA, but it is trying to recognize some of their rights under this particular act. So, what are the major rights that has been recognized under the Forest Right Act? Is majorly they wanted to recognize their land rights and the rights over the forest produce or the minor forest products. So, by this act they wanted to undo the historical injustice that has happened to the traditional forest dwellers, and they also wanted to provide legal ownership over the forest areas. Up to certain areas they will have land holdings there in the forest, up to 4 hectares of land will be given. Recognize the community rights, so individually they can own lands and community rights over the forest, and therefore they also help in conserving the forest, because we are talking about how PESA Act has helped in conservation of forest, because PESA Act also confers an administrative mechanism, gives power to the Gram Sabha, and a similar function is also done by Forest Right Act. So, this is basically what you will have to understand. The Forest Right Act also gives power over the minor forest produce, and in fact the Forest Right Act also empowers Gram Sabha to certain extent. It also promotes sustainable forest management. It also provides for what is called as community-led forest management. So, therefore, both the PESA Act and the Forest Right Act has helped in forest conservation, but that is not to say that these legislations are not having any drawbacks. It does have drawbacks, but despite there is a scope for improvement, they have tried to protect the rights of the people. So, that is what is the important article that was discussed. So, therefore, I thought that this question can also be relevant from the conventional area, where questions can merely come from what is called as Forest Right Act and the PESA Act. So, this is also an area. At least remember, PESA Act is applicable only in the Schedule 5 areas. So, that is even sometimes asked in the examination. Come to the next question. Just because we have seen the PESA Act, this is again important, although it is also part of the current affairs, that Ladakh is seeking a status in the 6th schedule of the constitution. Ladakh, which is presently an union territory, is actively seeking the 6th schedule in the constitution or recognition under the 6th schedule. Presently there are only 4 states or certain autonomous districts in these 4 states that is having recognition under the Schedule 6, that is in the state of Assam, Meghalaya, Tripura and Mizoram. Only these 4 states. But however, recently there was a protest which was spearheaded by Wang Chung, who is an activist there in Ladakh, and he himself has marched towards Delhi, and he wanted to seek special status along with the people of Ladakh to the Union Territory of Ladakh to be protected under the 6th schedule of the Constitution. Now, why they seek protection under the 6th schedule of the Constitution? What is the importance of 6th schedule? Because we know that once a particular area is there under the 6th schedule, then in that particular area the ordinary laws may not apply. In fact, under the 6th schedule of the Constitution, there are 10 districts in case of Assam, Meghalaya, Tripura and Mizoram are recognized as tribal autonomous districts. And the tribal autonomous districts have lot of powers. In fact, these tribal autonomous districts, they have financial powers, they have legislative powers, they have administrative powers, they have judicial powers. A lot of powers is conferred upon to these bodies, and because the tribal way of life is little different, so therefore here the autonomous districts will decide all those things. In fact, they can make their own laws, the tribal autonomous districts, and in fact in this tribal autonomous districts there will be a group of 30 people, out of which 4 can be nominated by the governor, others are elected by the people. And in the tribal autonomous district, there is a tribal autonomous district where the elected members, they make laws on certain areas which is authorized in the Schedule 6 of the Constitution. Alright, so they make laws, they also discuss about the various customs, and most of the things are decided based on the customary laws and all those things are allowed. They may have control over land, regulating shifting cultivation, inheritance of property, marriage, divorce, etc. So all those things are done by the autonomous district councils. So the autonomous district councils are relatively given lot of powers, and whatever laws it is made by the autonomous district council, they are to be approved by the governor of that particular state. And the autonomous district councils are also empowered to establish primary schools, dispensaries, roads, waters, and all those things. So these are all some of the important autonomy that is given to the autonomous district councils. Therefore, Ladakh today is also demanding that they be placed under the 6th schedule of the Constitution. Therefore, they will also get a similar autonomy. Alright, so this is what basically you have to understand. So because we have seen Schedule 5, Schedule 6 also important. Schedule 5 is in generally for the scheduled areas in all the states except Assam, Meghalaya, Tripura and Mizoram. Only in the Schedule 5 areas a PESA Act applies. In Schedule 6 areas, it is the autonomous district councils which will take care of the administration, and they largely have a lot of financial, judicial, administrative and legislative functions better than what is called as the Schedule 5 areas. And that is the reason why Ladakh is also demanding the recognition under the Schedule 6 of the Constitution. But anyways, it's a demand, we do not know whether it will be granted or not, but anyways, the people of Ladakh are demanding for it. The next topic that you want to discuss is recently 5 languages has been included as a part of the classical language. Now already there are 6 languages in India which was recognized as a classical language, and which was the first such language? It was Tamil was the first language in our country to be recognized as a classical language. Then it was Sanskrit, and then subsequently other 4 languages are added, which include Telugu, Kannada, Malayalam and Odia. So all these languages were added. Now in addition to that, another 5 languages added, so therefore it is now part of the current affairs. What are the new languages that has been added? So now recently Marathi, Pali, Prakrit, Assami and Bengali, all the 5 languages in addition to the existing 6 languages. But however, recently the criteria as to what shall be considered to be classic language was changed a little, and that paved the way for another 5 languages to be added. So before these 5 languages were added, what was the status, or how the classical languages status were given? So let us try to find out that particular criteria also. So what was the criteria before the 5 languages are added? So it is, one is antiquity, that how long they are old, minimum 1500 years to 2000 years. A body of ancient literature or text, they should have a lot of ancient literature and text which can be considered valuable. And then apart from that, there should be literary tradition and must be original and not borrowed from any of the other community. That means they should have their unique and their own tradition of literary works. And then apart from that, the classical language and literature being distinct from modern, There may be also be discontinuity between the classified languages and its later forms or its offshoots. These were the criteria that was given. Anyways, the criteria may not be very important for the purpose of examination, but you can have a fair idea. But you should know what has been relaxed recently and what are the new languages that are added and what are the existing languages. So these are all the very important areas from where question can come. Now, if you see, the tradition must have original and not borrowed. That means any language, they should have their own tradition and not borrowed from the other languages. Now, exactly this particular condition has been relaxed. The government relaxed the relaxation of for a language to have an original and literary tradition. So even if this criteria is not met out, still they can be given the classical language status. So and the experts say that this is not very important and this has to be relaxed. So therefore, the other languages can also be conferred what is called as the classical languages, based on which now Marathi, Pali, Prakrit, Assami and other Bengali has also been given the classical language. Anyways, it is for the government of India to decide as to what shall be given the classical language, and all these languages should be equally appreciated. What are the facts about the classical languages? So Tamil was the first languages to be recognized as the classical language in the year 2004. Subsequently, Sanskrit in the same year was also recognized as the classical language, and subsequent to that it was Telugu in 2008, then Kannada in 2008, Malayalam in 2013, Odia in 2014, and then subsequently in the year 2024 another 5 languages: Bengali, Marathi, Pali, Prakrit, Assami and Bengali has also been added to the status of classical languages. That means presently how many languages have classical language status? Presently there are 11 languages in India which has got the classical language status. Alright. Please come to the next topic. Supreme Court upholds Section 6A of the Citizenship Act. Again very important. Now what is the Section 6A of the Citizenship Act? Why it is important? Because the Supreme Court has upheld the Section 66A of the Citizenship Act. But if you ask me what is the Section 6A of the Citizenship Act, now Section 6A of the Citizenship Act was inserted into the Citizenship Act to give effect to what is called as the Assam Accord. Now Assam Accord is basically a tripartite agreement between different parties in order to mainly deport the illegal migrants who have entered into India from Bangladesh after a fixed cutoff date. And this cutoff dates was fixed by the Assam Accord, and subsequently these dates were inserted into the Citizenship Act by inserting that Section 6A of the Citizenship Act. Now first of all let us try to understand Section 6A, then let us try to understand on what grounds the Supreme Court has upheld the Section 6A of the Citizenship Act. In fact, Section 6A has many dates to determine whether an illegal migrant entered from Bangladesh into India would be considered to be a citizen or not. So therefore, the Section 6A talks about all these dates. Migrants who entered before January 1, 1966. Persons who entered before January 1, 1966, even though they are an illegal migrant, they can be considered to be a citizen of India for all purpose. Now, why this is very important? This is important because before 1st January 1966, the migration was very less. So therefore, it was not causing any problem. And also these people by 1985, when the Assam Accord has happened, because only after the Assam Accord, this amendment was happened to the Citizenship Act. By the time already they have stayed almost 19 years in India and they are well integrated with the country. So therefore, they may be given the citizenship, no issues, and not many people have entered. Now the second date is that migrants have entered between 1st Jan 1966 and before 24th March 1971. So that is till 24th March 1971. These are all people, again not too many people, but these are all very unstable time in Bangladesh. So therefore people have come to India and we allow them on a humanitarian basis. But however, these people will not be granted citizenship immediately. They have to stay in India for a period of 10 years after they are identified as an illegal migrant, and then they may be granted the citizenship. But however, the law was not allowing those people who entered after 24th March 1971, because by the time West Pakistan has launched the military operations in East Pakistan, and there was a lot of people who migrated. In fact, it is said that more than 1 million people migrated from Bangladesh into India, and that has created a lot of problem to India. In fact, the demography of some of the northeastern states in India started changing. Therefore, these people may not be given the citizenship as per this particular act. So therefore, they have to be identified and they have to be deported back to Bangladesh. So migrants who entered on or after 24th March 1977, they are all considered to be illegal migrants. Now all these provisions were upheld by the Supreme Court of India, which was basically part of Section 6A of the Citizenship Act. Now, what was the reason that was given by the Supreme Court of India to uphold all these provisions? The Supreme Court of India said that these provisions were valid considering the humanitarian grounds and also the need to protect the identity of our own people and the interest of our country. So, somewhere these provisions are balanced. So, therefore, the majority opinion of the Supreme Court has upheld this particular Section 6A of the Citizenship Act. Now, what is the Section 6A of the Citizenship Act is related to identifying the illegal migrants entered into India from Bangladesh. So, just try to remember this. Alright, so with that we will move to the next topic. AFSPA is back in 6 violence hit areas in Manipur. We know that for the past few years a lot of violence is happening in Manipur, very unfortunate. But a side effect of this violence is AFSPA has been extended to certain areas in Manipur. Now, what is this AFSPA? AFSPA means Armed Forces Special Powers Act. In fact, this has colonial roots in our country. If you look into the origin of Armed Forces Special Powers Act, it can be rooted to the British rule. During the Quit India movement, they started bringing in such provisions, and subsequently they brought in an ordinance which later became a law in our country and continue to be a law. And now presently if you see this Armed Forces Special Powers Act, they are used in some of the northeastern states, especially where an area is declared to be what is called as a disturbed area. If you look into Section 3 of the Armed Forces Special Powers Act, Section 3 is saying that any area is declared to be a disturbed area by the governor of that particular state or the administrator of an union territory or by the central government. In those areas which is declared to be a disturbed area, the Armed Forces Special Powers Act can be invoked. And once invoked, this Armed Forces Special Powers Act, the Armed Forces Special Powers Act gives a lot of powers upon the armed forces. Say for example, the armed forces personnel may have the power to open fire upon the people. Even if it results in death of the people, still the Armed Forces Special Powers Act may provide certain level of immunity to the armed forces personnel. They can conduct searches, they can seize properties, all those things can be done under this. So an extraordinary power is given to the armed forces personnel, and a certain level of immunity is also given to them for the action that they do under the Armed Forces Special Powers Act. So today presently the Armed Forces Special Powers Act, if you see, they are invoked in some of the northeastern states. So what are the states today they are invoked? They are invoked in some of the parts of Nagaland, Assam, Manipur and Arunachal Pradesh. But it has been done away with in some of the states also. It has been done away with in states of Meghalaya and also in Tripura. But still it continues to be in the northeastern states. So therefore, you should have an idea as to what is this Armed Forces Special Powers Act, who can declare an area to be a disturbed area, where these Armed Forces Special Powers Act is used, what are the powers that is given to the armed forces, where the Armed Forces Special Powers Act is invoked. It has its own criticism, but it still continues to be a law in our country. Now come to the next topic, guidelines for playing what is national anthem. In fact, this controversy has happened in the state of Tamil Nadu. What was the controversy that has happened in the state of Tamil Nadu? The governor of Tamil Nadu, Mr. R.N. Ravi, before making his customary address in the State Legislative Assembly of Tamil Nadu, he walked away from the State Legislative Assembly of Tamil Nadu. In fact, we know that the governor during the first session every year and also the first session after the general election makes a formal customary address, and where he reads out the content that is prepared by the government, which is subsequent to which the motion of thanks is passed. But this year, that is in 2024, beginning this year, Governor Mr. R.N. Ravi has walked out without making the customary address from the State Legislature of Tamil Nadu. What was the allegation from the office of Raj Bhavan in case of Tamil Nadu is that Governor was not happy with the fact that at the beginning of the session, the national anthem was not sung. Instead of national anthem, what has happened is Tamil Thai Vazhtu was sung. That means that's a local theme or a song that is used in the state of Tamil Nadu as per their local customs and local tradition. But Mr. R.N. Ravi was not happy with this. So therefore, this is not something for us to make a judgment, but let us try to understand as to what is a constitutional provision in this regard. In fact, if you look into the constitution, something that can be related to this is only the part 4A of the constitution. That is the part 4A of the constitution, which talks about what is called as the fundamental duties. The fundamental duty says it shall be the duty of every citizen to respect what is called as a national anthem, national flag and all those things. But however, by not singing the national anthem, is there a disrespect? We do not have an answer to that particular question, because there is no such law which is explicitly saying, and different state legislature, they do have their own conventional practices. A matter was filed, in fact a case was filed in the Madras High Court, that in any public functions, if the national anthem is not sung, therefore it should be, there should be some mechanism to punish them, or there should be a mandamus from the court or a direction from the court to sing what is called as a national anthem. Therefore, when this petition was filed in the Madras High Court, the Madras High Court made it very clear there is no such rules that has been framed to this particular regard, and hence therefore without the rules to direct anyone is not possible. Although when there is a national anthem, there are certain acts which mandate us to respect the national anthem, like the Prevention of Insults to National Honours Act, but not playing the national anthem probably in a public function, can it be seen as a disrespect? We do not have any specific rule in this particular regard. So that is what has been held by the High Court of Madras. So therefore, try to understand in this particular context. So there is no question of whether it should be done or not, but can not singing the national anthem at any public function can itself be seen as a disrespect to the national anthem. The High Court have said that there is no specific rule, and hence the High Court is not in a position to direct a mandamus in this particular regard. Alright, so please come to the next question, the next topic, that is 3-language formula controversy. Again, this is a controversy that is happening between the central government and some of the southern states, especially the state of Tamil Nadu. Now, what is this 3-language controversy? What is the present context? The Tamil Nadu government has written to the central government stating that the central government has not released funds related to PM Shri scheme. PM Shri is an educational scheme in our country, which is a centrally sponsored scheme, but a corresponding fund has not been released by the center to the states in the opinion of state of Tamil Nadu. The center is saying we are willing to release it provided you are following the 3-language policy in your school system. Now, what is this 3-language policy? Initially, which was brought in by the National Education Policy in 1968, for us to understand. So, in the National Education Policy 1968, for the first time this 3-language policy was brought in. What is this 3-language policy? National Education Policy mandates that in the schools in India that the 3 languages shall be followed. If it is a non-Hindi speaking state, the 3 languages could be, one is their regional language, that is their mother tongue or regional language, and then the second is English, and of course the third would be what is called as Hindi in a non-Hindi speaking state. But however, if it is a Hindi speaking state, it would be their regional language, and then in addition to that English, in addition to that preferably any one of the southern Indian languages. So this would be the 3 languages that will be read. So probably in the North India it would be a southern language, and in the southern India it would be Hindi in addition to the regional languages and English. This is basically what is called as a 3-language formula. And the same was revised in the National Education Policy 2020. And here also almost a similar policy, although it does not mandate Hindi as the 3rd language. It could be any of the other language also, but ultimately the opinion of the state governments, various state governments, is still the central government wanted to promote what is called as Hindi. Now this is what is a 3-language formula, but if you see in case of Tamil Nadu, from the very beginning they have been following what is called as a 2-language formula. Whether it is right or wrong, we are not getting into that. What are the 2 languages that they follow? The 2 languages that they follow is English in addition to their own regional language, that is Tamil. And if you look into their history, there has been a continuous agitation against the imposition of Hindi, and consistently this 2-language formula has been followed. And even in the new education policy 2020, the Tamil Nadu government has not implemented the 3-language formula. Therefore, the center is saying that you implement the 3-language formula, the state is adamant that we will not implement the 3-language formula, and therefore the center has also said the moment you will start implementing 3-language formula, we will release the funds. So this issue is happening. In this context, we shall understand as to what is this 3-language formula controversy. Please come to the next article. The important current affairs is Article 311 of the Indian Constitution. Now, why this Article 311 of the Indian Constitution is very important? Because invoking the provisions of Article 311 of the Indian Constitution, the Lieutenant Governor of Jammu and Kashmir has dismissed some of the government employees from the state of Jammu and Kashmir, from the Union Territory of Jammu and Kashmir. Therefore, what is this Article 311 of the Constitution? Article 311 of the Constitution provides a protection to the government employees. In fact, what kind of protection is given to the government employees is Article 311 of the Constitution makes it very clear. If at all any government employee is to be removed from the service or dismissed from the service, they cannot be removed from by any authority who is subordinate to the appointing authority. That means, first of all, you should understand who is appointing authority for the government employees. By virtue of Article 309 of the Constitution, the appointing authority is the President in case of union, and in case of state it is a governor. And further, Article 311 of the Constitution is saying, and further Article 310 of the Constitution is saying that they hold office during the pleasure of the President and the Governor respectively. But the pleasure doesn't mean that the President and the Governor can remove them at any point of time. It has to be read along with Article 311 of the Constitution. What is Article 311 of the Constitution is saying? That no person in government service can be removed by an authority subordinate to the appointing authority. That is what is Article 311 clause 1 is saying. What is Article 311 clause 1 is saying? No person subordinate to the appointing authority can remove that particular person or dismiss that particular person from the service. But whereas Article 311 clause 2 of the Constitution is saying, although the person can be removed by the appointing authority, only the subordinate authority cannot remove, but the appointing authority can remove. But even the appointing authority cannot remove a person without giving him a reasonable opportunity of being heard. That means if the government wanted to remove a person, first of all, the other person who is to be removed should be given an opportunity to explain his case. That means a proper inquiry has to be conducted. Only based on the inquiry, he or she can be removed or some action may be taken. So, due process has to be followed under Article 311 clause 2 of the Constitution. So, therefore, Article 311 clause 2 of the Constitution is trying to protect the public servants from being removed from their service. But however, there is an exception to this Article 311 clause 2. What are the exceptions that is given in the Constitution itself? The inquiry and the opportunity may be skipped in following situations. When the inquiry may be skipped, 1, when there is an official, when the official is convicted by a court, because the court has already found him guilty. So, therefore, there is no need to conduct a new inquiry. Where it is not practical to hold an inquiry due to reasons of breakdown of discipline, riot, etc. There are certain emergency situations where you are not able to conduct the inquiry. Under such a circumstance also, without an inquiry, you can dismiss the person. Where the President or Governor is satisfied that holding such an inquiry is against the security of the state. Now, here if you see why this has become relevant, that I have said that few officials in the government of Jammu and Kashmir has been dismissed by the Lieutenant Governor on the ground basically that these employees were having some terror links. Therefore, if an inquiry is conducted, it may go against the national security. In those cases also, without an inquiry, still they can be removed from the service. In fact, this exception was used by the Lieutenant Governor to dismiss them from the service. So, this is basically in this context you have to understand. Article 309, Article 3010, Article 3011, all these articles are very important, and in fact, Article 312 is also very important. If you know what is Article 312, please put it in the comment box. Very, very important. It is the power of the Parliament to create what is called as a new All India service. But to create a new All India service under Article 312 of the Constitution, the Rajya Sabha has to pass a resolution. And what is the majority with which the Rajya Sabha has to pass a resolution? Put that in the comment box. Please come to the last topic, that is the third national Lokpal to be established. In fact, it has been established. And as per the newspaper reports, you can see that over 1 crore cases, that is 10 million cases, was solved in one single day by this Lok Adalat. So, you can see the advantage of the Lok Adalat. In fact, Lok Adalat is a system of what is called as alternate dispute resolution mechanism in our country. Instead of people going to the court, they can go to the Lok Adalat and get their cases resolved and settled. In fact, if you see this, the genesis of this Lok Adalat today is based on what is called as a Legal Services Authority Act 1987, and this Lok Adalat is also what is called as a People's Court. The advantage of this particular Lok Adalat is there is no strict procedures as it is followed in the courts. People can have reconciliation, people can have mediation, people can have other ways of settling this particular dispute in what is called as a Lok Adalat. And the procedures are very easy, it is very flexible. So that's why Lok Adalat is becoming very popular, and the judiciary is also giving a lot of impetus to discuss and to settle a lot of cases through Lok Adalat, because that is going to substantially reduce the burden upon the Lok Adalat. So now the question is, what type of cases may be entertained by the Lok Adalat? The Lok Adalat can entertain both civil as well as petty criminal cases. But however, the nature of the cases should be compoundable offences. What do you mean by compoundable offences? Compoundable offences are generally those offences where the punishment is usually less than 2 years. Very minor criminal cases. So those cases may be taken up. Lok Adalat can take up cases which are new, which has not gone to the court. It can also take up cases which is already pending in the court. So both these cases can be taken up by the Lok Adalat. So here I have given a list of cases where or what type of cases can be taken by Lok Adalat. Criminal offences, compoundable nature, cases involving traffic challans, revenue cases, bank recovery cases, motor accident claims, check dishonor cases, labor disputes, matrimonial disputes, excluding divorce cases. Even in matrimonial disputes, but excluding divorce cases, other cases may be taken up. Land acquisition cases, intellectual property rights or consumer matters, and other civil matters. That means they can include both civil as well as criminal matters, but criminal matters only compoundable in nature. Matrimonial cases, yes, but not divorce cases, because for divorce there is a separate family courts. Now try to understand all these cases may be taken up by the Lok Adalat. Again, the questions may come from the Lok Adalat also, which is basically an important alternate dispute resolution mechanism in our country. So all the topic that I have discussed today is very, very important. For the purpose of brevity, I kept the discussion very short, but I have told the very relevant points which may be asked in the examination. I am sure that you have seen 50 topics in the last 9 lectures or so, 9 episodes. If you see the current affairs series, which will not take you more than 3 to 4 hours. So even if the students are not watched it till this point of time, still you have the time before you go to the prelims examination. If you are appearing for 2025, I'll suggest you watch this at least once so that you can retain the information. Even if you can solve 2 to 3 questions, even if you can solve 1 or 2 questions from these 3 to 4 hours, it would make a lot of difference in terms of your performance in the examination. And if you want to watch the questions from these 50 topics, which I am planning to do a live session coming Sunday 2 p.m. in the IAS Mentor channel. So we'll meet you in the live channel. If you like in the live a discussion of the question and answers, multiple choice questions. If you like this particular episode, please share it with your friends and family members. And I'm very sure in the coming years, it is going to be helping lakhs and lakhs of students preparing for UPSC examination. Thank you very much for watching this particular video. All the very best.